Welcome to The Market That Moves America, a podcast from the National Center for the Middle Market. The center is the leading source of knowledge, leadership, and innovative research on the middle market economy. Throughout our podcast, we will feature middle market leaders and stakeholders to hear their real-world perspectives on trends and emerging issues.
In our last episode, we introduced the importance of intellectual property for middle market companies. We continued that discussion in part 2 with a focus on trademarks. Welcome to The Market That Moves America. I'm Doug Farron, Managing Director at The Ohio State University Fisher College of Business, National Center for the Middle Market. We'd like to welcome you back to part 2 of a conversation that we started in our last episode, which was on intellectual property. And our guests were Bryan, Wheelock, and Joe Walsh from Harness IP. I'm welcoming back Bryan and Joe today. Thanks for joining me for part 2 of this conversation. We're going to continue talking about some other facets of intellectual property, specifically at middle market companies. But maybe for the benefit of those who weren't able to hear our prior episode, first of all, welcome back to you both. And would you just mind sharing a little bit about your background, experience, and your role with Harness IP?
Sure, and thanks for having us back, Doug. So I'll start. My name is Joe Walsh, and I've been an IP lawyer now. And IP, for those of you who have heard the term or expression but may not know what it means, it really covers patents, trademarks, copyrights, trade secrets, and related litigation and licensing. And that's what I've dedicated my legal career to, which is patents, trademarks, copyrights, related litigation and licensing. I am a registered patent lawyer. I'm also a very active trademark lawyer and a copyright lawyer, as is my colleague and law partner, Bryan Wheelock. And we've been law partners for over 25 years now, maybe 28. So the overwhelming majority of our careers we spent together, and we do a lot of work together with common clients. So Bryan and I started the St. Louis office of Harness IP. It's going on 22 years. It'll be 22 years this year. Our firm just celebrated its 102nd anniversary, so we're one of the oldest and largest intellectual property boutique firms. And what I mean by that is that's all we do is patents, trademarks, copyrights, related litigation and licensing, and we do it all over the world. So we have a team of dedicated associates in every industrialized country of the world where we help protect our clients' intellectual property in the U.S. and using associates throughout the world. So that's my background, 36 years of experience. I'll turn it over to Bryan. He's got a few more years of experience than me.
Yeah, I have a similar career to Joe's in that I'm a licensed patent attorney, but I ended up doing just a little bit of everything in IP, and that's what I really enjoy is handling any aspect that comes along, solving the particularly hard problems. I also get a kick out of teaching IP, and I've been teaching law school for 20 years in addition to working full-time here at Harness IP. And with about 40 years of practice under my belt, I think I'm well-versed in just about anything that's going to come along, but I would always like to be challenged.
Yep.
Awesome. Well, it's great talking to you again. And just again, for a little bit of a recap on our last episode, we really introduced this topic, the broader topic of intellectual property as it relates to mid-size company, which of course is our focus here at the NCMM. And, some of the differentiation between things like copyrights and patents, and more importantly, why companies need to think about these things and why they're so critical. Today, I want to go into maybe a little bit different direction and focus on something that was brought up toward the end of our last conversation, which was names and trademarks. So, interestingly, a majority of the middle market, the privately held companies, a lot of B2B companies too, where, maybe they think about their brand name or certain things that might not be as critical to more consumer-facing types of companies. So let's just start there. Names and trademarks. What do you see when dealing specifically with mid-sized clients?
Mid-sized clients usually seem to be reactionary in their activity. They start to get concerned about protecting their name or brand when they see a challenge or someone appears on the scene, where a little advanced preparation would have made a big difference. And I think if I was going to give advice to the collection of them, I think it's important to consider what you want your identity to be. Be intentional and conscious about what your identity is instead of being reactive. Oh, clients like that name, or we never really thought much about it, or they like the our orange packaging. Think in advance. What is going to distinguish you? How do you want to be distinguished? And protect those aspects. And that goes for names and brand, marks as well. So think about what the mark should be and how you want to protect it, and then go about it. Joe and I were just talking about this the other day. A lot of clients come to us and, oh, yeah, no, don't worry, don't mess with our name. Our lawyer, registered the name and it's all fine. Registering the name as your corporate name or as a fictitious name, that doesn't protect the mark at all. In fact, a lot of the state forms tell you that if you look at them closely. What we do is protect the name itself with either state or most likely a federal trademark registration that gives the company nationwide rights. And it's important to get those nationwide rights. The big advantage of getting that federal trademark registration, there are a bunch. The first is you get to use the cool little R in the circle symbol. So that warns people, hey, this thing is registered, keep off. But the other thing it does is it reserves the mark throughout the country for ease of expansion. So if you get the registration, you're starting out, you've got the Midwest pretty well covered, but you're not using the mark in Maine or California yet, although you certainly plan to. If someone comes along and innocently adopts the mark and you don't have a registration, they'll end up owning it in those remote areas, and you can only expand so far. But if you get the federal registration, anyone who comes along after the day you file, is junior to you, and you can kick them out. And so it's particularly important for a business that's starting up and growing or has hopes of expanding to get that reservation, right? The name is reserved throughout the country. If someone doesn't already have it, they're not going to get it. And that's the importance of registering your name as a trademark. So a trade name is a name that a business does business under, and it can also be their trademark, the name they put on products, and it could also be their service mark, which is the name they put on their services. And it's registration is the tool to get that. It's not very expensive to get, and the rights it confers are well worth it if there's even a hint of a dispute.
Yeah. So I've got a bunch that I'd like to add as well, Doug, if it's appropriate.
Yeah, please.
Okay, so I love trademark law. It's really interesting. People, whenever we give a presentation, trademark law is what everybody pays most attention to. But there are a couple of rules that should be adhered to. Number one, if you are truly a small business operating in a small geography, for example, like you operate only in the state of Missouri or only in the state of New York or only in the state of Ohio, I recommend you get a state trademark registration, not a federal trademark registration. And this applies to people who run like barber shops, landscaping businesses, catering services, things of that nature. They really have no plans to expand outside, a 3-city area or whatever. Don't spend the money to get a federal registration, because then you have the obligation. The thing about trademarks is, unlike patents and copyrights, you can let people infringe your patents and copyrights without much consequence, as long as you don't let them do it for more than 6 years. But with trademarks, if somebody's infringing your brand, you have an obligation to legally go after them and stop them. Otherwise, you lose your trademark rights. So why bite off the United States if you know you're only going to use the brand locally? Get a state trademark registration. It's a lot cheaper. You only have to protect it, in the area where you're actually operating. That applies probably to 10% of our clients. 90%, are selling on the internet. They're selling on Amazon. They need federal protection. So it's very important for them to get the federal registration. Let's talk about, Bryan he talked about trade names, trademarks. Trade names are things. They're nouns, right? Trademarks are always adjectives. They modify the noun. So, and a lot of our clients don't get this. They think that you can just protect, a slogan or a term in the abstract, and then use it in text. No, that is antithetical to trademark use. So, just do it. Nike, they have that as an expression. Let's build something together. I think it's Lowe's has that as an expression. And then you have, a whole host of trademarks out there, but they're always used. It's Adidas brand sneakers. Tide brand dish detergent. If you can insert the term brand between the mark and the noun, the thing, you're using the brand correctly. If you're using the brand as a noun, buy my Adidas, buy my Nikes, that's incorrect trademark usage, and it'll blow up in your face ultimately because you go to assert your rights against somebody and they say, hey, you're not using it as an indicator or source. You're using it as a thing, as a common thing or as a descriptive term. So how you use your trademarks is really important. Now let's go back. Let's wind the clock back a little bit. What are trademarks? Trademarks are adjectives, as we said. It can be a logo. It can be a design. It can be a word. It can be a phrase. It can be a sound. NBC's bing, bing, bing. The three.
Right.
That is a registered trademark. So you're in the kitchen washing the dishes. You hear bing, bing, bing on the TV. You're tuned to NBC, right? And Bryan brought this one to my attention. There is a brand of knitting yarn that smells like plumeria blossoms. So you walk into a yarn store and you just follow your nose to the plumeria blossom scent, and it'll take you to this one brand of yarn. So really a trademark can be anything, that identifies products or services from a single source. That's the key, and it's really key because if McDonald's didn't protect its McDonald's brand for the Big Mac, and everybody was using the Big Mac, you could not come to count on that same flavor, when you bit into somebody else's Big Mac that you can count on when you bite into a McDonald's Big Mac. And that's really key because brands, we as consumers now, we buy stuff all the time on Amazon, right? Amazon's coming to your house. You like something like, I like these clog footwear things, right? And I wear them all around my house, my yard. Well, I bought a few and they don't have any brands on them. And I want to buy them again because I like them so much, but there's no brand on it. So I don't know where to go, so I'm going to invariably wind up buying a different brand from somebody else because I can't go back to this guy. So brands are really important. And last week I was in New York visiting one of my nephews who owns a Christmas tree farm. And he showed me this really cool Christmas tree stand that has a peg up the center of the bottom of the stand. And he drills, when he sells his Christmas trees, he drills a hole in the base of the Christmas tree so that it can sit on that peg. And then when you screw the little screws together at the bottom, the tree stands perfectly straight. And I said, wow, that's a great tree stand. Tell me who makes that? And there was no brand on that. So, there's a product that I would have gone out and bought had I known what the brand was. But now I'm not going to get it from that producer. So brands identify products from a single source in the marketplace, and they allow customers to distinguish, between different suppliers of products. So
Sure.
There's a whole lot to trademarks. It's a lot of fun, but basically what they do, and they have to do this, they have to do two things in order to continue to be a trademark. And that's why Kleenex and Xerox are in trouble now because people are saying, give me a Kleenex when really what they mean is a facial tissue. Or give me a Xerox when what they really mean is a photocopy. But, in order to be a protectable trademark, it has to identify products or services from a single source and distinguish them from the competition. And it has to do both of those two things at all times. And if it fails to do one or the other, then it fails to function as a trademark.
There was a trademark issue near and dear to us here that was announced last year. So the university won a trademark for the word "the."
Right, right. I remember that.
And it's interesting because regionally we say OSU, and it's understood that you're talking about Ohio State, but there's also Oregon State and Oklahoma State.
Uh-huh.
So I think part of the argument was, the use of that word, and now we have that trademark to use for licensing and branding of apparel and goods and all types of things. So,
right.
So conversely, I'm sure you've had instances where maybe a client goes to file and maybe somebody else already has that trademark. Have you seen examples of that?
Okay, I'm going to pop in here again, too, because I've got two really stellar examples. That was a point that I was going to make, but I said so much else that I forgot about this. Absolutely. There is a right way, to go about adopting a brand. And the right way is not to sit around in a room and have six people talk about what they like and then say, okay, we're picking this one, let's go protect it. The right way is to come up with several different options and then talk to someone like us and have us do some searching to gauge the availability of that for the use that you intend. Now, I'm going to give you 2 examples, and these are both wealth advisors. I won't tell you their names, but wealth advisors came to me, and they've been in business for like 5 or 6 years. The one guy got a cease and desist letter from somebody in California saying, hey, we just learned that you're using our brand. He's been in business for 6 years. He's got a big sign up on his building that he spent $25,000 for. Guess what? He's got to take it down. He's got to take it down. So because he went about it the wrong way. So he had to go back through a whole rebranding process. Think about all the clients that he developed over 6 years. And now he's got to go back to those people and tell them, hey, I'm changing my name and my website's changing and all that stuff. You know, what a bunch of heartburn and wasted expense. So this happens a lot. It happened. So now I got another guy who's also in the financial realm, but he's going about it the right way. He heard about the other guy, I think, and he's getting ready to put a big sign up on his building. And he said, hey, I thought maybe I should contact you first. And I said, good idea. So we're going to walk him through that process as well. But the key is you know, particularly today when you're selling products all over the world, you know, you have to know who's out there. And if there's a competitor in the United States, common law rights count, as Bryan pointed out. You know, in most other countries of the world, it's first to file. Whoever gets there first is the winner at the trademark office. Not in the U.S. You know, you can be sitting on a trademark registration that you've got, and unless you get to the 6th year point, if you get to the year 6 and you file this certain document that now makes your registration incontestable, if you get that, then you're fine. You can't lose your registration because somebody else used the same mark earlier. But if you don't get to that 6th year part, and somebody say 3.5 years into you're happy, you're thinking, oh, I got my brand registered and everything. Okay, 3.5 years, somebody knocks on your door and says, hey, I can show I used it 5 years before you ever even filed your application. Guess what? You'll lose that registration. So don't do a search. You know, spend your money wisely. It's money well spent. And I know it's hard. I've had to counsel clients to move away from marks that they, you know, as a group fell in love with, but tell them they can't protect it. You're gonna spend a lot of money and time, and the whole point of doing a search is to make the path clean and easy for you to move forward. And then now you have rights that you can absolutely protect and assert against other people without fear that somebody's coming after you.
Right. I think that one of the big mistakes that people make is they think of a mark and they fall in love with it before they call us.
Right.
And that's when really bad decisions are made. They hear we did a search. There's some things that are pretty close. You might want to think, oh no, this is it. This is the mark that's going to, you know, spill the company. And they end up with disputes about the mark or trademark oppositions in the trademark office, a lawsuit in federal court. And it's because they were too attached to the mark before they found out that the mark was available.
And I'm going to say, you know, this is just a matter of ignorance. It's not a matter of conscious disregard. But a lot of business lawyers don't really understand trademarks. So when a client comes to them and says, I want to start a new company, here's the name, and he runs off and, as Bryan pointed out, registers it with the Secretary of State in that state, you know, he thinks it's protected now. And the client thinks it's protected, but it's not. That's simply a trade name, a noun registration, which enables the state to collect tax from you. And if you hurt anybody in another state, they know where to find you and all that kind of stuff. It's a simple registration process. And the Secretary of State's, what they will do is they will register the same darn marks if they're one letter apart, you know, or one word apart. They'll register them because it's not a prosecution system. They're not trying to determine whether there's any likelihood of confusion. It's just whether they're identical or not. And that is a completely separate matter from protecting a brand or protecting a trademark. You know, registering a trade name is not the same as protecting a trademark. And a lot of people don't get that.
So what I'm hearing, the takeaway here is doing that little bit of due diligence up front before you fall in love and having a couple options available is well worth the time to avoid headaches down the road.
Absolutely.
So when is the right time to have that conversation? Is it when, like, at first ideation, or when that conversation is happening within the company?
As early as possible.
As early as possible. Okay. Got it. And then let's say you have clients that discover that their trademark is being infringed upon. I mean, what do you do from there? What level of involvement do they have, and how do you go about protecting that registration?
Well, the client has to decide, is this really a problem? A lot of people get pretty proprietary about their marks. They're using it, if the mark's being used in an entirely different business and in a remote area, maybe it's better not to worry about it, because consumers are pretty savvy and they can distinguish between the same brand being used on entirely different products. And so if you get too proprietary, you'll spend all your time and effort and worry trying to enforce rights. But if it is something that, no, that's an area of natural expansion, or it is in our area, it's a competitive product, or there's substitutes, then you need to go after it. If you let one person in, then how do you stop anyone else? So if you let someone have a confusingly similar mark, then your mark isn't that distinctive anymore, and then another can come in with another slightly different mark.
Well, it goes back, Doug, to what I said about trademarks, right? They need to do two things. They need to do those two things at all times. Identify your product or service in the marketplace and distinguish it from the competition. If they feel that, if you allow, as Bryan said, if you allow number two in and he's got just a letter different than your brand, he uses an uppercase E instead of a lowercase e, or he uses a U instead of an E, and he's got the same products or whatever, and you let him in, you've opened the door to 3, 4, 5, whatever, and that just dilutes the value of your brand and maybe actually kill your brand over time. So,
right.
But I will say, the question you asked initially is, you got salespeople out in the field, right? And as Bryan said, people get very selfish and protective about their brands. And you get the salespeople out there and they come back to management in the company and hey, Bob, look what I found here. There's a company over here and they're doing something and it's similar to ours. You need to get our lawyers after those people and take care of them or whatever. And everybody gets whipped into a frenzy. And next thing you know, there's a phone call and everybody's hot and blah, blah. You really need to be cool and calm about these analyses, because you can blow a lot of cash and, for no reason whatsoever. And with social media being what it is today, you have to really be worried about being the big bad, wolf. So, here it is, the big guy beating up the little guy and all that. If really they're not if they're not hurting your brand and if they're not hurting your sales, you might think about just letting them go.
That was going to be my follow-up. Is it incumbent upon the company to prove that they've been damaged, or just like basically there's a threat of being damaged? How do you distinguish between that?
Yeah, that's a great question, and a lot of people don't draw that distinction. The proof of damage will be presumed if the marks are similar, so you can get a court to say, "Hey, stop it! Two people can't be in the same space with the same mark." If you want money damages as compensation, then you're going to have to prove, we've lost something, because the courts just don't hand it. Despite what you may think of after reading the papers and in the online news, courts don't just hand out money. So. But the damage is generally presumed if the marks are the same and the goods are the same or closely related.
Yeah, remember what we said earlier about damage. They will hand out the money if you have a successful copyright claim where your registration is infringed, and you can access the statutory damages, but no statutory damages for trademark. So you have to prove money damages, which means you have to prove lost sales. That you would have made those sales, they were diverted away to these guys because of the brand, and that's really hard to prove. So, so you get into a lot of disputes over damages.
What type of mark do you see as being more important, a logo or a name, or do they hold equal weight?
It depends on what you're using. Logo, the words generally are stronger just because people can remember them. Particularly if the logo isn't a swoosh. A swoosh or something, but if you remember Nike and you can ask for Nike, you can Google Nike. You can't Google swoosh as well. You can try, but it doesn't come out as well. But that said, the swoosh is highly valuable. And
they paid $70 for that to a graphic designer back in the late 70s. And felt bad over time. They got an assignment of all rights from her. And I think I read just 3 or 4 years ago, they gave her like $750,000 worth of stock.
Yeah, they felt bad with that much money. So they're both important, and it's really, the company may fall in love. Oh, we love that logo. The founder's daughter drew it, or they can fall in love with something. It doesn't make any difference if the customers don't. It doesn't resonate with the customers, because those are the things that an infringer is going to copy. We kind of want people to think this goes with their product or we're related or something, and they're going to try to simulate it. So it's the important marks to protect are the marks that when they get copied, everyone in the company goes, uh-oh, or holy crap, we got to stop this nonsense.
And it happens with colors too, Doug. People don't realize it, but color is protectable as a trademark. There are a lot of brands out there or a lot of companies that make things. We have a big client who makes all of their products in green, and we registered actually the color yellow, I think, for underground irrigation piping for one of our clients. Because usually irrigation piping is PVC. It's just white. It comes out extremely white, but you have to put a special pigment in there, and it costs you more money to make it yellow. But there's no reason why everybody else has to make theirs yellow. So our clients, are the only guys who can make yellow irrigation piping. And when you see it, it comes from them.
Yeah, there are lots of color marks that are pretty famous. Brown for UPS, the fuchsia color for T-Mobile, orange is a color that's the theme for Home Depot.
Yeah, and the one that started it was Owens Corning with the fiberglass, the pink fiberglass, because fiberglass, that's extruded, that's actually colorless. And so you have to impart a dye to it to make it pink, which costs more money. And they did it because they wanted all pink insulation to be known from Owens Corning.
Yeah, interesting. So kind of to wrap up, I've heard a couple things today. This has been really, really interesting. Mid-sized companies should start thinking about this as early as possible. They need to have options and not be necessarily wed to things until they have everything filed properly. And then should issues arise, try to maintain a sense of calmness and work with professionals like yourselves to kind of figure this out and not get too bent out of shape. Would that be correct?
I think that's absolutely accurate. And one thing I would recommend too, Doug, is what we do. For our longstanding clients, we tell them typically we're willing to meet with you twice a year for an hour. If you want us to come and talk to your people, we're happy to do that. You just pay our plane fare, but we won't charge you for our days, our hourly rate for our day of contribution to you. We'll go and talk about any question. I told you earlier about the one client that we had with they reconfigured their product so that they could make an adaptable part, the disposable part. That changed their business. And that was a 2-hour conference over lunch, So what I would recommend is for any company that's kind of struggling, feeling a little amorphous about, what are we going to do with IP? Bring in IP counsel and say, look, guys, either, we'll pay your airfare and you come out and chat with us, or let's do a Zoom call or whatever. And maybe say, we want $500 of your time or whatever. And we're going to hit you with a couple issues and we just want to get some feel. So because people are always thinking, let's not get the lawyers involved because they're so expensive and they're just going to, mire us down. And well, I'll tell you what, we're really practical guys. We understand how important and expensive this stuff is. We're conscious of all that. So, and if you say, I want $500 of your time, we'll give you everything you need. And $500, just kind of a big overview. You tell us what the issues are. We'll tell you what direction to go in. So you can dictate, how much time you want a lawyer to spend on something. It's not just open the spigot and let them go. So,
Yeah.
So if I was going to identify, that getting trademarks or getting a strong trademark, it's kind of 5 steps. The first is that clearance. Know what's out there before you start using the mark. Then do get that registration as early as possible because it locks you in and locks everybody else out. Use the mark properly. There's certain rules that, any lawyer would tell their client, follow these rules so you don't weaken commit suicide.
Adjectives, not nouns.
Right. Those types of things. I mean, I've always talked about the acid test, for use. Acid, A, you're using it as an adjective. C, you use it consistently. I, you identify it as a mark, little asterisk, registered trademark, or, this is a trademark of action
TM
company.
or SM.
Or TM or SM or in the circle if you got that federal registration. And then the D in acid is distinctive. Make the mark stand out. If you just treat it as a normal word, you're not showing your own mark, your own identity respect. Make it bold, make it colored, make it stand out so people know.
Have it float on the web page.
So you use it properly. Then the last two, spend some money advertising the mark, not just the product. the look for advertising, look for the color brown, look for the
Texaco did the best job in the old days. Look for the star.
You can trust your car to the man who wears the star, is the slogan. So advertise the mark. And then lastly, strategically enforce it. Don't go after everybody. Go after the ones that you really should go after. Because as Joe said, you let other people into the marketplace, then you can't stop it. Once you have one uninvited guest, you have a house full.
Yeah. Great advice. Well, hey, I'd like to thank you both again. Another really fascinating conversation. I know I learned quite a bit, specifically as we spent a lot of time in this discussion around trademarks. And I think a lot of the advice that you shared, would be extremely helpful for middle market companies who might be struggling with this or thinking about their own kind of trademark and copyright and larger intellectual property issues. So if any of our listeners would like to learn more about Harness IP, you can visit their website at harnessip.com. And Bryan, Joe, thanks again for joining me today.
No, thank you, Doug.
Thanks for having us, Doug, and we're happy to join you anytime.
Okay, great. Thank you, and everybody have a great day.
All right, bye now.
Bye.
Bye.
Thank you for listening to The Market That Moves America. Never miss a new episode by subscribing anywhere podcasts can be found. You can also subscribe to our email newsletter at middlemarketcenter.org.